Hi everyone, today we will be discussing online legal agreements and whether or not it is recognized in South Africa. So with the world constantly evolving with online advancements and the internet being the biggest medium, we need to consider the uncertainty of whether online agreements would be legally recognized in South Africa. So there are many websites on the internet that provides legal contract templates that can be used for personal or business purposes. Free contracts can be downloaded on our website if you guys are interested in just seeing what a contract entails or what it looks like. You can find it on our website once again. So it has become important to understand what a legal agreement is and what renders it valid and enforceable in our law. An agreement consists of an offer being made and an acceptance of such an offer for an agreement to actually take place. So the agreement becomes binding and enforceable on all parties once the offer has been accepted. There are certain elements that needs to be complied with whether the contract is electronic or written. It will be enforced against all parties and considered valid if these elements has been complied with. When I say these elements, I mean elements such as the parties who does conclude the contract must have the contractual capacity. So when I say the contractual capacity, I mean, for instance, if one of the parties to the contract is a minor, his or her parents or guardian needs to act on his or her behalf. If one of the parties are mentally unfit, the courts will appoint a curator bonus or a curator ad litem to contract on his or her behalf. The contract also needs to be valid and not lawful and not prohibited by any provision in South Africa. So when I say this, an agreement cannot be valid if you guys agree to commit a murder or a crime or such as fraud or murder, etc. There are different types of agreements. I'm just going to discuss a few for you guys just to understand what an agreement actually is. So you have lease agreements, which is an agreement where the lessor undertakes to grant a lessee the temporary use and enjoyment of a property for a certain amount of money and for a certain period of time. You also have a service level agreement, which is an agreement between an organization and their service provider. This agreement does set out obligations and expectations of the relationship between the parties. You also have most commonly known as a prenuptial contract or a prenup. In South Africa, we do not refer to it as a prenup. We do refer to it as an antenuptial contract. It is an agreement that regulates the terms and conditions of a marriage. And this agreement is entered into before the marriage in order for this agreement to be valid. You also have a Paris Agreement. This is an agreement which was adopted by 195 countries on the 12th of December 2015. It is an agreement to the United Nations Framework Conventions on Climate Change. This agreement was adopted to address climate change and its negative impacts and aims to reduce the global greenhouse gas emissions in an effort to limit the global temperature increase. Then you have certain legislation that does govern agreements. For example, if you look at a credit agreement in terms of the National Credit Act, in order for this agreement to be classified as a credit agreement for the purposes of the National Credit Act, it must have two essential characteristics. Firstly, credit must be extended with some deferral of repayment or prepayment. And secondly, the credit provider must impose a fee or charge interest on deferred payments, or the credit provider must provide a discount on the prepayment. There are also three types of credit agreements described in the National Credit Act. Firstly, you have a credit facility, which is a check account overdraft, a credit card or a retail store card for credit, for example, like a Mr. Price account or a Foschini account or a macro account. There are many. Then you also have, secondly, a credit transaction, which is a form of payment deferral that attracts fees or charges interest on the deferred payments. You also have a credit guarantee, which is an agreement where the guarantor agrees to pay what another person owes in terms of a credit agreement should the debtor fall in arrears or default. So we also have verbal agreements. So there's an argument in our country of whether or not it should be accepted. However, it is strongly recommended to have a written agreement drawn up, as verbal agreements offer no record of details discussed between parties, so there's no proof of what you are insinuating or alleging in our law that it is true and correct. However, verbal agreements in South Africa is recognized. You also have to look at the legal validity of online legal agreements between parties, such as e-commerce or electronic commerce. So the term e-commerce or electronic commerce is an agreement or contracts concluded wholly or in part through communications over computer networks, such as emails or websites or online stores, etc. This type of agreement falls into three broad categories. The first is the sale of physical goods, which mostly arises over the internet. For example, if you are shopping on Takealot or Superbalist and those kind of stores, this is considered as the sale of physical goods. Then you have a legal contract for the supply of digitalized products such as software, which is your Microsoft Office or Teams and all of that falls under this category. Then you have the third category, which is the supply of services and or facilities such as video conferencing mediums. This is your Zoom and your Skype and so on and so forth. The principles of legal contract law do apply to online agreements and are considered to be valid and enforceable against all parties in South Africa. So they must also comply with the elements of a contract to be valid. When I say the elements, I mean that they must have the contractual capacity, there must be consensus, it must be lawful, the formalities needs to be complied with. Those kind of elements that I've discussed in the beginning. What does a contract or an agreement actually look like? You have a legal template which typically contains certain clauses, such as the parties to the contract needs to be disclosed, the nature of the contract, what are you selling, what goods are you selling, what service are you providing, the date of the agreements, there needs to be a signature on the contract. You need to have clauses for when there's a dispute, what happens when there's a breach in the contract. This is typically the type of clauses that you will insert in a legal agreement. So the Electronic Communications and Transaction Act was enacted in South Africa to regulate online legal agreements, since there is a lot of uncertainty. So it governs this agreements, like I said, and the main purpose of this act is to promote legal certainty in respect to electronic communications. This act also states that digitally negotiated and electronically signed contracts are fully valid and enforceable in South Africa. However, this act also provides for instances where electronic signing of an agreement would be invalid. For example, concluding an agreement to alienate or dispose of immovable property, or concluding an agreement for a long-term lease of immovable property, for example, 20 years or more. South African courts are still deciding on the issue and restrictions of electronic signing. So it is still a very vague part in South Africa. There's not a lot of experience in this area, if I might add. Then we also need to consider another issue we do have in South Africa is the jurisdiction over online agreements. When I say jurisdiction, I mean the competency and the power of the court to hear and decide on a certain matter. For a court to have jurisdiction, there are two elements or two requirements that we need to look at. The court must have the authority, firstly, to hear the matter. There must be a link between the court and the party. For example, the party resides within the area of the court, or the cause of action arose within the court's district. The second one is that the court must have the power to enforce its judgments. So electronic commerce is trans-border and does not acknowledge geographical borders. The general rule here is that a contract must be determined according to the law where the contract is made. In Latin terms, this is most commonly known as your lex loci contractus. I'm not sure if I'm saying this right because I do not speak this language. I do not speak Latin. However you feel comfortable pronouncing this, it's okay, as long as you understand what it means. And yes, so the Electronic Communications and Transactions Act adopts the reception theory. Now, what is this theory? This is when a contract is formed, or this means, in fact, that a contract is formed at the time and the place where the offerer receives acceptance of the offer, and the acceptance does not have to come to the knowledge of the offerer for it to be legally binding. When I say this, I've read another case where I'm going to use this example. The person resigned via an SMS, and the employer did not have knowledge. So the employer decided he's going to go to work on Monday, and then he said, no, it's not a legal termination of the contract. However, the court did find that it doesn't matter if the employer looked at the message or saw the message, as long as he received it in data, it means that the contract was terminated. So this is the theory we accept in our law. Jurisdiction will, however, remain a worldwide uncertainty when it comes to online legal agreements. We also have certain terms that we need to look at with regards to legal agreements. You have a shrink wrap and you have a click wrap, and then you have a web wrap agreement. So shrink wrap and click wrap is also known as a blister pack. It's when agreements become valid and enforceable when the software package is installed. So the minute you've installed your Microsoft Office, this is when the agreement is valid and enforceable. You also have web wrap, which is when an online customer wants to purchase products offered through an e-shop, for example, your Takealot. He or she will be instructed to click on certain icons indicating acceptance. For example, do you agree with the terms and conditions? You'll obviously have to read the terms and conditions before clicking that you accept and that you agree. So those are your web wrap agreements. Section 24 of the Electronic Communications and Transactions Act, provides for the valid expression of the intent to make an offer or acceptance via data messages, and is not without legal force merely because it is in data form and without electronic signatures. So in concluding, since we are a technologically advanced era, the law now recognizes this and is constantly updating to make such agreements valid and enforceable. This is an attempt to help the vulnerable and just to bring certainty to the law. So if you guys did enjoy this legal online lesson, please like and subscribe to our channel, and just to stay updated with when the next